I noticed that your syllabus on torts and damages has been radically changed if we base it on the 2011 syllabus. It's a good thing because the original syllabus here in 2011 and 2012 talks about American torts. They even have the concept of battery, and the concept of battery is different from ours. It's a good thing this has been changed. Okay. There was this case in 640 SCRA 621. The case of international free port traders. Let me just say it. I don't want to stand up right now. In the case of international free port traders versus Danzas International, that's 640 SCRA 621, and that was decided on January 26, 2011. It emphasized that there are several stages in the life of a contract. In fact, this is not a new doctrine. This is a very old doctrine, simply reiterated. And the first part in the life of a contract is what they call preparation. Sometimes they call it the stage of conception, the stage of generation. Then the second stage is the perfection of the contract. This is where the contract begins to exist. And consummation. Paki-close up mo yun. Okay. So these are the basic stages in the life of a contract. And this has been so for decades and decades. The first part is actually the stage of where there is an offer, there is a counter offer, the parties negotiate, the parties offer the terms, the other party rejects the terms and makes a counter offer. But when there is a meeting of the minds, there is a perfection of the contract. But remember, a meeting of the minds is not enough to perfect a contract in certain contracts, like real contracts, where what do you need? Delivery. And in a formal contract, what do you need? A form. Okay. Now, when the parties have already complied with their obligations under the contract is said to be consummated. The contract is now dead. The contract is extinguished because the obligations under the contract are extinguished. Now, you've been reading your law on contracts, and let me ask you a very simple question. What are the effects of what are the consequences of the perfection of a contract? You go to 1315. Oh, there are strip seals here. I did not know. Okay, let me open this. Hirap namang open yan. Okay. Look at 1315. What is the consequence of the perfection of a contract? The parties are bound to fulfill what they have stipulated. I'm using my own words, including the consequences of that stipulation. Do you see that? In keeping with good faith, in keeping with usage, and in keeping with law. Those are the consequences of the perfection of a contract. You are bound by these stipulations, you fulfill the stipulations, all the consequences resulting from that stipulation, but it must be in good faith, keeping of usage and the law. Let me ask you another question. Is transfer of ownership a consequence, necessary consequence of the perfection of the contract? Answer, in some contracts, yes. In some contracts, no. Where could there be a transfer of ownership by the mere perfection of a contract? Look, in a formal donation. You do not need delivery for the donee to own the property as long as the contract of donation is perfected by following the formalities. Look at this. I donate to you an immovable in a public document. That public document actually specifies the property donated. That document specifies the value of the charges which the donee must satisfy. Then the donee accepts it in a public document also. It was accepted in a separate document. He gave a notice to the donor in some authentic form. And that step was noted in both documents, the document of donation and the document of acceptance. There is already a donation. There is already a transfer of ownership. Follow me? If the donation exceeds 5,000 pesos, the donation was in a private instrument. It was in writing. It was also accepted in writing. There is already a donation. There is a transfer of ownership. Delivery is not a consequence. Delivery is not necessary to transfer ownership in those donations. But when the donation does not exceed 5,000 in value and it is immovable, then you need delivery for the transfer of ownership because there is a requirement of a simultaneous delivery of the thing donated or the document representing the thing donated. That is 748, that is 749 of your civil code. Now, is there a transfer of ownership when a lease is perfected? There is none because lease does not transfer ownership. It only transfers possession and use. When a contract of comodatum is perfected, is there a transfer of ownership? There is none. What is a comodatum? What is its purpose? What is its object? What kind of object? A thing that is not to be consumed, is it not? I borrow your car. You deliver to me my car, your car. There is a perfected comodatum. But there is no transfer of ownership. I only have the right to use the car and return it later. There is no transfer of ownership. Even if there is a delivery, there is no transfer of ownership. Because the purpose of comodatum is for me to use it and then return it later. There is no transfer of ownership. Now, let us talk about simple loan. When I borrow something that I intend to consume, that is a simple loan. That is mutuum. When I borrow money, that is a mutuum. That is a simple loan. I told you, can I borrow can I borrow from you 1 kilo of rice? I've got a lot of visitors right now. What am I going to do with the rice? To exhibit the rice? No, to use it and cook it for my visitors. When you deliver the rice to me, is there a perfected contract of mutuum? Yes, because it's a real contract, there is delivery already. Do I become the owner of the rice? Yes, ownership is transferred in mutuum. But I have also the obligation to pay you later also with the same kind and quality. Okay? Now, if I borrow money from you and I said, can I borrow from you 10,000 pesos? And you said, yes. Is there already a mutuum? None. There is yet no delivery of the money. Now, when you deliver to me the money, is there now mutuum? Yes, it's a real contract. It requires delivery. But, incidentally, when it is delivered, I become the owner of the money. That's motuo. I offered to sell you a car for 500,000 pesos. It's a second-hand car. And you said, yes, I accept. Is there a perfected sale? There is. Because the sale is a consensual contract. Is ownership already transferred? Not yet. Because a sale is not a mode of transferring ownership. It is only a first step in transferring ownership. A sale is not the mode of transferring ownership. Could you look at 712 again? You already have looked at it. Those are the modes of acquiring ownership. It should be 712. Do you see occupation there? 712. Do you see occupation? Yes. Do you see intellectual creation? Yes. Do you see law, meaning by operation of law? Yes. Do you see donation? Yes. Donation is a mode of acquiring ownership. Do you see succession? Yes. The moment my parents die, I am the only son, I am the only heir. I own the property by operation of law. Next. Is there sale? There is none. Do you see tradition there? That should be pronounced not the way you pronounce customs and traditions. It's tradition. Tradition as a consequence of certain contracts. Tradition refers to the jurisprudential Spanish name for delivery. Delivery as a consequence of certain contracts. When you go to the law on sales, Professor Oribe is going to talk about traditio longa mano, traditio brevi mano, traditio constitutum possessorium. Those are various types of delivery. But they forgot the Filipino mentality. People in the Philippines, when you say traditio longa mano, you're pointing at the thing. But they forgot that people in the Philippines point with their lips. So they should have invented traditio longa labia. Yeah, lips. But there is none in our books. Tradition as a consequence of certain contracts. See, the sale itself does not transfer ownership, but a sale requires no form for the validity of the sale. A sale could be oral, a sale could be writing, a sale could be partly in writing, a sale could be partly oral, it could even be inferred from the conduct of the parties. That is a sale, the perfect consensual contract. You look at 1483. I hope it is, because it uses by word of mouth. 1483, not 1482. 1482 is an earnest money. You go to 1483. Sige, look at 1483. Mira el artículo 1483. Look. Could it be in writing? Yes. Could it be by word of mouth? You see the traditional words we had? By word of mouth. Bakit? May word of ears ba? May word of nose. Hindi na sinabing oral. Okay. Could it be partly in writing, partly by word of mouth? Yes. Could it also be inferred from the conduct of the parties? Yes. Okay, for example, I go to a mall. There are food stands in a mall, okay? And I saw there just a sign. Japanese corn, 50 pesos per cup. Help yourself. I got one, ate it. Throw in the garbage. I got one, ate it, throw it. I ate one, Again, 3. Then I left. Then the tendera said, Mama, bayad. Sagot ko, bakit? Nag-usap ba tayo? Bumili ba ako? Nagtitigan ba tayo? No. Kumain lang ako. Should I pay? Yes. Was there a sale? Yes. There was an offer. I accepted by eating. There is a meeting of the minds. It was inferred from the conduct of the parties. There is no provision of law which says a sale of land must be in writing. 1483 is the basic provision together with 1475 because a sale is perfected by the meeting of the minds. Listen to this. You sold to me, you offered to me your refrigerator. Okay? I said, babayaran ko na ha. Ibigay mo sa akin bukas ang refrigerator, wala akong van. Hindi kasi sa kotse ko yan. Sabi mo, bukas ko i-deliver. Binayaran ko na, umalis na ako. Second hand. Am I the owner? Is there already a sale? Oh yes, obviously there is a sale. In fact, I already paid. Am I already the owner of the refrigerator? Bayad na eh. Am I already the owner? No. No, payment does not transfer ownership in a sale. So what do we say? Akin na yan eh, bayad na yan eh. Sagot ko, ano kung bayad? Hindi pa ako may-ari. Pero ako ang may-ari ng pera. Pero hindi ikaw ang may-ari ng refrigerator. That's a sale. Because in a sale, it is not payment or perfection of the sale that transfers ownership. It is delivery. You look at 1477. You look at 1477, the ownership of the thing sold is transferred upon the delivery, either actual or constructive. Did you see it? It is the delivery that transfers ownership. That is what Article 712 means by tradition or delivery as a consequence of certain contracts. Delivery as a consequence of the sale transfers ownership. Sale first, perfection, then delivery, transfer ownership. Sale only, perfection, no transfer of ownership. Sale, perfection, payment, no transfer of ownership. There is a sale. I offered to sell my car to you for 200,000 pesos. No, 500 naman. Okay. Then you said, I accept. There is perfection of the contract. Get what I mean? I delivered the car to you already. You still have not paid. Are you the owner of this car already? Yes, because delivery transferred ownership. But you owe me money. That you are the owner of the car. You go to 1496. You go to 1496. That is the same principle as in 1477. Did you see it? Ownership is transferred also upon delivery there by the modes of transferring ownership in the articles mentioned up to 1501. So you will notice the essence of 1477 is the same as 1496. Delivery transfers ownership. We always have the impression na kapag binayaran mo na yon, ikaw na ang may-ari. No. Ang nagpapamay-ari sa iyo ay ang delivery sa iyo. It may be an actual delivery, it may be a constructive delivery, it may be a symbolic delivery, but you are going to study that under sales. I'm telling you the basics. Delivery transfers ownership. Is there a situation when there is delivery, there is no transfer of ownership? Yes. In 1478. And a contract to sell. Because the parties stipulate that ownership in the thing shall not pass to the purchaser or the buyer until he has fully paid the price. That is a contract to sell. I delivered the thing that you wanted to buy from me. I delivered it to you. But I told you, you will not become the owner until the price is fully paid. The payment of the price is a suspensive condition before the sale could arise. That is not a contract of sale. It's only a contract to sell. Ownership is withheld pending the full payment of the price, even if there was delivery. Even if there was delivery, there is no sale. On July 11, 2012, in the case of David versus Misamis Occidental Electric Cooperative, on July 11, 2012, the Supreme Court said, when there is delivery, but the parties agree that ownership will not pass to the buyer even if there is delivery, and ownership is withheld pending full payment of the price, there is no contract of sale. There is only a contract to sell. But when the price is fully paid and there has been previous delivery, there is no need to make any further delivery because it has been previously delivered. He becomes automatically the owner of what has been previously delivered to him. It becomes a sale. The sale arose because the suspensive condition was fulfilled. It's contract to sell and contract of sale. In a contract of sale, why are you supposed to know whether or not there was a transfer of ownership already? Why are you supposed to know? So that you will know who will bear the risk of loss. Remember the doctrine, res perit domino. The owner bears the loss. Oh, there are many schools of thoughts on this. But as a bar reviewee, you must select a view. The best view is 1504. You look at 1504. That is not based on an opinion. That is based on law. Before ownership is transferred, who bears the risk of loss? Come on, the owner. Did you see that? That's the best provision that you should rely upon in case the issue of res perit domino comes in. Sino ba ang owner? Ang seller. Bakit? Wala pang delivery. Nawala ang thing without his fault. He bears the risk of loss. Dineliver na sa akin, I bear the risk of loss. See, look at this. There were many actual cases like this, okay? Nanghiram ako sa iyo ng 10,000. This is a representative example of various cases that reached the Supreme Court. I borrowed 10,000 from you. You gave the 10,000 to me. Then I walked 2 blocks away. I was held up. Who will bear the risk of loss of the 10,000? Me or the lender? Me. Why? I am the owner. In simple loan, when the thing is delivered, I become the owner of the money, right? I bear the risk of loss. Next question at the bar exams. Do I still have to pay the 10,000? Pare, wala na akong utangan na hold up ako eh. Yung inutang ko sa'yo, hinold up. May obligasyon pa ba akong magbayad? Yes, because money is generic. You get me? Money is generic. Hence, I still must pay. You look at 1262 and 1263. only specific things are lost. A class is never lost. Assuming this is a dog, this dog is named, give me a dog name. Dog. I cannot think of it. So this dog is named Dog. Okay. Never mind. Dog. This could die. This could be lost. But the class dog to which it belongs will never be lost. In other words, this dog may die, but the dogness of dogs will remain. The dogness is the class. It will never die. Genus non quam perit. Now, so you combine it with respirit domino. In the bar exams, do not be confused. Do not answer according to the view of Tolentino, according to the view of Padilla, according to the view of Horado. Then you say, I agree with so and so. You will not finish the bar exams. You are not there to answer in a very scholarly manner. You are there to give your point. You select. This question has to be resolved in relation to ownership. The owner bears the risk of loss. It has been delivered to the buyer. The buyer is now the owner. He bears the risk of loss. Very simple. That's why you have to know who the owner is. Now, let me ask you one question. Is there an instance in sale where ownership is not transferred by delivery, but where ownership is transferred because of mere consent? What is the rule in sales? Ownership is transferred by delivery. 1477, 1496, except if it is only a contract to sell in 1478. Can you follow me? But is there an instance in a sale where ownership is not transferred by delivery, but by consent? Yes, but it is not found in the law on sales. It's found in the law on pledge. Try to go to 2097 for a while. Take note. When you pledge a thing, it is in the possession not of the debtor, but in possession of the creditor, or a third person by mutual agreement. And the thing pledged may be alienated by the pledger. Get my point? But it is still subject to the pledge. So let's say I pledge my diamond ring to Mr. Brillantes. Oh, nice name. A diamond ring to Mr. Brillantes. He's in possession of the ring. Can I sell it? Oh, Sybil is there. Can I sell it to Sybil who is there? Yes, because I can sell what I have pledged. However, he will remain in possession. When will ownership be transferred? Answer, when he consents to the sale. It is an instance where ownership is transferred by consent. Could you go on reading 2097? You cannot see it on my forehead. When the pledgee consents to the alienation, ownership is transferred. Well, can you see it? Did you see the word consent? Sus, tagal. Did you see it? Yes. Yeah. That is a transfer of ownership by consent and by not by delivery. But even if you become the owner, the pledgee will still hold it because he is the creditor until it is paid. Do we understand each other? Yeah, you have to. Okay, see that? That's only 1305. It's very long. And the syllabus that we have gives us the impression it's too short. See, look at your syllabus. 5 item lang. Now, there are several principles involved in a contract. And the most important principle, which has been part of the bar exams even before, is the doctrine of freedom of contracts. The doctrine of liberty of contracts. They are one and the same. The doctrine of autonomy of contracts. Freedom of contracts, liberty of contracts, autonomy of contracts. Are we allowed to enter into stipulations, clauses, terms, and conditions? Can we establish those things which we may deem convenient? The answer is yes. Huwag lamang labag sa batas. Huwag lamang labag sa moralidad. Huwag lamang labag sa kagandahang kaugalian. Huwag lamang labag sa pampublikong kaayusan. At saka panglipunang kapayapaan. It must not be contrary to law, morals, good customs, public order, and public policy. Those are the limitations to the freedom of contract. Those are the limitations to the liberty of contract. Those are the limitations to the autonomy of contracts. What is the implication? These limitations are superior to our freedom of contract. Now, during the early days, during the infancy of our civil code, this is the new civil code. We used to have an old civil code. During the infancy of the new civil code in 1949, 3 years after, there was the first case in 1306. And that first case was, you don't have to write this, the case of Louis A. Allied Workers versus Court of Industrial Relations, the forerunner of the NLRC. This was decided on April 29, 1951. Okay. The workers had been rendering overtime compensation for 2 years. And after 2 years, they banded together, formed a union, and asked for their overtime compensation from their employer. The employer said, when you started your employment with this company, you signed an employment contract where each and every one of you, the employer said, renounced the right to overtime compensation. It reached the Supreme Court. The Supreme Court said, that stipulation is immoral. That stipulation against public policy. There was yet no law at the time. So, it's contrary to public policy. It's contrary to morals. The stipulation was struck down as violative of, as an exception to the freedom of contracts. Then many years after, in 1999, in 313 SCRA, number 1, in the case of Asia Recruitment Corporation versus NLRC, there was a similar situation. Here, the workers signed a collective bargaining agreement where they agreed that the employer has a right to make and effect a summary dismissal. The Supreme Court said that is not in accordance with law anymore. There is no such thing as a summary dismissal. The freedom of contracts is limited by the requirements of the law. There was another situation where a partnership was formed. I just forgot the name of the case. A partnership was formed. There were 5 partners. 4 of them were capitalist partners, and 1 of them was an industrial partner. One capitalist partner gave the biggest contribution, and in the articles of partnership, there was this stipulation that that particular partner will share in the profits, but that capitalist partner will not share in the losses. Oh, there was a quarrel among them. It even reached the Supreme Court. Now the issue was that provision in the Articles of Partnership a valid stipulation? See, he will share in the profits, but he will not share in the losses. He was able to impose that because he had the biggest contribution. He contributed 85% to the partnership. One was an industrial partner. Now, if you are asked to resolve it, is it an exception to the freedom of contracts? Is it a valid stipulation? Is it contrary to law? If it is contrary to law, then you must tell us the law. Because obligations derived from law are not presumed. Only those expressly stipulated in the law are supposed to be recognized. Remember 1159? I just paraphrased 1159 because I don't want to mention the technical wordings of the law. Do the partners have the obligation to honor the stipulation? The other partner said, no, we will not honor that. Then there must be a basis in the law why they are not going to honor it. Could you visit 1799 for a while I am taking a nap? It's void, isn't it? Yes, it's void. Let me try to... Oh, I did not bring my glasses again, but never mind. I think I told you 1799. Let me try this. James, I'll borrow this for a while. Let me look at it. Where is it? Oh, James. Ito ang part na walang kulay. Hindi mo nabasa. Talatang ayaw mo ng partnership. The stipulation which excludes one or more partners from any share in the profits or losses is void. So the stipulation that the capitalist partner is exempt from losses is a void stipulation. Now, is there a partner who need not share in the losses? Yes. The industrial partner. Because if the partnership loses, he already has lost because his labor and services went to waste. But he will share in the profits in accordance with that which is equitable because he has no capital contribution. You go to 1797. I think that's the provision that will tell you. Did you see that? He could be exempt from the losses. Industrial partner. Is it really 1797? I think it is. No. I'll wait for you. I'm not in a hurry. I have the whole Saturday to finish this. Okay. Did you see it? And industrial partner is exempt from losses, but he could share in the profits, that which is just and equitable. Why? Because you cannot quantify it really in exact monetary terms, so that which is just and equitable. Okay, I mortgaged my coconut land to Mr. X. The deed of mortgage prohibits me, the mortgagor, from alienating the property mortgage. The mortgagee said, this is our contract. You cannot sell it. You cannot alienate it. Is the stipulation a valid stipulation? You look at 2130, it may guide us. Now, let me also look at my 2130 here. Okay. Let's do this together so that it would have meaning. What you do, I will do. If you don't look, I won't look. Okay. A stipulation forbidding the owner from alienating the immovable mortgage shall be void. So I cannot be stopped from selling the property mortgage. However, if I sell the property to someone else, the mortgage follows the property, whoever the owner is. Because a mortgage creates a real right over the real property, it follows the property. Whoever the owner is, it is still subject to the mortgage, even if there is a new owner. You know, there was this case several years ago, not too long ago. This was 1999. The case of Liton Hua versus L&R Corporation. It was in 320 SCRA 405. Yes, I remember it. 320 SCRA 405. The mortgagor and the mortgagee entered into this stipulation. The mortgagor has a right to sell the property mortgage with the prior consent of the mortgagee. The mortgagor said, that is void. The mortgagee said, it is not void. You are not prohibited to sell. You can sell it in accordance with 2130, but holy smoke, you get my consent. Is that a valid stipulation? There was no absolute prohibition to sell. The only condition if you want to sell is get the consent of the mortgagee. Is that a valid stipulation? The Supreme Court said no. Because suppose he does not consent, you cannot sell it. It is a circumvention of the law. It's still a violation of 2130. You are very serious again. You smile. How was your makbar? Are you okay? If you do not get 75 above there, don't worry. That's the reason they call it a makbar. It's a practice one. You take the makbars. Just practice. So what if you get low? It will even tell you, hey, you study more. You should know more. If I were you, I would take it. Sir, suppose I get only 10. So what? If I get 10, I will no longer go down. I will go up. If I am down, the tendency is not to go down. The tendency is to go up. That is something that would buoy up your spirits. Dapa na ako eh. Hindi na ako pwedeng padapain pa. Ang kasunod nito, tatayo na ako dahan-dahan. Hanggang mag-peak ako sa bar. Wow! Kung bakit ba pinoproblema niyo yung bar? Umiinit ang ulo niyo dahil sa bar. Wag uminit ang ulo dahil sa bar. Hindi nyo kasi alam na marami na kayong alam eh. Yan ang problema ninyo. Hindi nyo alam na ang dami nyo na dyan. Stock knowledge, lahat yan, par value. Umupo ka sa isang sulok, hindi mo matatandaan ang binasa mo. Hindi yun ang natural. Pero tanungin ka, meron kang masasagot. Dahil mahuhugot yan sa isip mo. Basta nabasa mo lang. Hindi ka pwedeng masiro. Ang checking dito sa inyong bar, basta may sagot kang medyo reasonable, hindi ka pwedeng isiro. Ang masisiro ka kung wala kang sagot. Kung ang sagot ay north, ang sagot mo ay northwest, northeast, pasado ka. Huwag lang south. Huwag lang south. Minabasa ko yung kay Sara Villanueva essay exams. Bigla akong natawa doon sa inyong tanong na yung may voting trust agreements, etc. At saka kung sino ang maka-exercise ng appraisal right, ang management contracts. That was nicely asked. Kasi wala namang appraisal right sa management contract eh. Nakuha nyo? Niloko kayo ni Castro dun. See? Pwede pa kung merger or consolidation, sale or substantially all of several assets, shortening or extending corporate life, yun. Meron pang isang nakakalokong tanong eh. Hindi ko lang maalala. Yung anong nangyari sa isang direktor na kailangan palitan? Ano ba? Expiration of the term? Ha? Di ko na maalala. Pero ang essence ay, ang dapat mag-elect ng kapalit doon ay stockholders, hindi directors. Sinong highest doon? Si Miss Suyat. Yes. Suyat. Minsan doon nakaupo, minsan dito. Ngayon wala. Sasabihin ko kay Atty. Uribe akong gagawa ng ibang MCQ at tanong sa contracts. Kung ayaw niyang pumayag, siya na lang. Okay. Look at this. I mortgage my property. The deed of real estate mortgage has the following provision. In case the debt is not paid on the due date, no demand is necessary to put me in delay. And my creditor mortgagee can now own the property and sell it the way he wants it. Valid or void stipulation. Look, I am mortgaging my property in favor of Mr. Mortgagee. If I do not pay my debt on the due date, I will now be automatically in delay. 1169, there is a stipulation. Get what I mean? And he is now the owner of the property which he can sell the way he likes it to do. Is the stipulation void? Yes. It's a pactum commissorium. You look at 2088. That's the mother provision on pactum commissorium. The creditor cannot appropriate the thing given by way of pledge or mortgage. He cannot do so. But to be a pactum commissorium, it must be a stipulation that authorizes the creditor to have an automatic appropriation of the thing. If it is not an automatic appropriation, it is not a pactum commissorium. Listen to this. If I do not pay my debt on the due date, I am automatically in delay. And I bind myself to execute a deed of sale of the property in favor of my creditor. That is not pactum commissorium. The appropriation is not automatic. I still have to perform an act, the act of executing a sale. That is not pactum commissorium. Okay? Now, because the rule is, if the debt is not paid, in case there is foreclosure or pledge, there must be a public sale to give the debtor a chance to have a higher payment for his property. If it is automatic appropriation, he is bound by the amount. But if there is a public sale, there is a highest bidder, and he still is entitled, could be entitled to a higher price. That's why pactum commissorium is not allowed. But 2088 is not the only provision on pactum commissorium. There is also a similar provision in Article 2137, which has a similar context, a similar meaning. Because the creditor under 2137 does not acquire the ownership of the real estate for non-payment of the debt within the period agreed upon, every stipulation to the contrary shall be void. Did you read 2137? That is also a pactum commissorium. Because the rule is, you either file an action to collect the debt or you foreclose. You foreclose. Mr. G, meaning Mr. G, letter G, lost a gambling match in the house of Mr. W, the winner. He had already paid the winner 200,000 pesos, but he still owes him 100,000 pesos. He executed a promissory note to pay him 100,000 pesos on or before a certain date. He did not pay despite demand. Can Mr. W, Mr. Winner, validly sue him in court for the collection of the balance of his gambling losses? This is an old bar exams. The answer is no. You go to 2014. That stipulation is a void stipulation. It is contrary to law. Because under Article 2014, no action may be maintained by the winner. The loser may even recover his losses with legal interest from the winner. See that? But if you apply that in your daily life, you will be shot. That is the law. That is the law. Okay. I'm reminded of a beautiful case that was not really an old case. It was a case decided on February 5, 2010. So it's 611 SPRA. I don't remember the page. It could be 657 or 658, but maybe 657. This is the case of the cousin versus the cousin. This is a beautiful case. These are Filipinos, but the husband became an American citizen, and they divorced in Nevada abroad. Okay? They divorced. And they drew up an agreement to have joint custody of their child who was only 5 years old. This is 611 SPRA. When they came back to the Philippines, the husband also came back, but already divorced from the wife. In fact, they did not live together. And the husband wanted to enforce an agreement made in a foreign country, so he filed an action to enforce the foreign agreement, to enforce the agreement on joint custody of a child less than 7 years old. It went to the Supreme Court. How do you think did the Supreme Court rule on the agreement of joint custody? Do you think the Supreme Court would consider it a valid stipulation? The answer is no. Because according to the Supreme Court, there is a provision in the family code I don't remember it. It might have been Article 213. Do you have a civil code there, a family code? That a child less than 7 years old cannot be separated from the mother? According to the Supreme Court, that provision does not authorize a joint custody. That provision gives to the mother the lone custody. And lone is not joint, the Supreme Court said. That provision gives to the mother the lone custody. Who are mothers here who have children less than 7 years old? In case you separate from your husband, you have the sole custody of the child. Okay? If the stipulation is contrary to law, do not forget Article 5 of your Civil Code. You look at it, look at Article 5. Acts executed against the provisions of mandatory or prohibitory laws. That's the provision, isn't it? Shall be void, isn't it? Except when the law authorizes their validity. Now, are there acts that are void? Are there contracts that are void? Yes. For example, a husband and wife cannot sell property to each other under the law on sales, unless there was a separation of property in the marriage settlement or a judicial separation of property. So it is prohibited by the law. It is an act prohibited by the law. This provision is a prohibitory law. If you violate it, the act is void. You look at 1490. Is it really 1490? Yes, it is. Yeah, you cannot sell property to each other, your husband and wife, unless there is separation of property in the marriage settlement or a judicial separation. And what does it say? A judicial separation in accordance with what? Article 191, but you will not find 911, 901 in your copies anymore. Rex Bookstore took it away, is it not? It's already in the family code, maybe Article 134 to 135, but no longer Article 191 of the Civil Code. Now look at 1491. Those are also prohibited acts. Those are also prohibited sales. Guardian and the ward, the agent principal, except if there is consent. Executor, the judges in relation to the property, the litigation within their jurisdiction, etc. Those are also prohibited sales. They limit your freedom of contract. Can we, the litigants, the plaintiff and the defendant, execute an authorized agreement waiving the jurisdiction of the court? No, because jurisdiction is conferred by law. It cannot be conferred by agreement or taken away by waiver. That's a void agreement. Do you remember Pacto de Retro Sales? If there is no agreement as to the period of redemption, what is the period of redemption? For years. If there is an agreement, it cannot exceed 10 years. In one case, in Celanova versus Mendoza, the parties agreed that the period of redemption is more than 10 years. What did the Supreme Court say about that stipulation? That is a void stipulation because 1606 tells you that it should not exceed 10 years. It's a decided case. Look at 1606. This is an old case, Celanova case. It's in 64 scrap. The period of redemption there is only has a maximum of 10 years if there is an agreement. Okay? Freedom of contracts. Autonomy of contracts. liberty of contracts. But we also have 1308. But, you know, I just skipped 1307. 1307 is about the nominate contracts, right? It simply tells us what regulates nominate contracts. By the way, I'll just talk about it in passing. What regulates nominate contracts? Ano ang nag-govern sa nominate contract? Well, common sense. Una, stipulation. Kung walang stipulation, ang sabi dyan ay provisions daw of Title 1 and Title 2 of this book. Ano bang this book? Book 4. Ano yung Title 1? Obligations. Anong Title 2? Contracts. So, obligations and contracts. Number 3, the rules governing the most analogous nominate contracts. Most analogous nominate contracts. Gaya ng, I give that you give. See? Do at this, I give that you give. That the most analogous contract there is barter. Is it not? So it will govern in the absence of stipulation, the absence of a provision in obligations and contracts, then the law on barter will apply. And then fourth, custom and usage of the place. Well, this could be what we call a runaway question if it is given, meaning it will be totally unexpected. But you expect the unexpected sometimes in the bar. Like, who is the president and what is the nationality of the president of the International Court of Justice? That's 2006 political law. Nauntog talaga ako sa kisame sa galit dun. Talagang nagsalita ako laban sa chairperson. Tapos tanong pala sa inyo sa bar, what governs nominate contracts? Okay. You have 1308. This doctrine reflects the principle of mutuality of contracts. The contract must bind both contracting parties. And its validity and compliance cannot be left to the will of one of them. This is a redundancy, of course, because a contract is a meeting of the minds. So its validity and compliance cannot be left to the will of one party. But the law in 1309 authorizes something, that the determination of the performance of the contract may be left to the will of a third person. But that determination shall not bind the parties until it is communicated to them. Look, in a contract of sale, can we delegate the designation of the price of the thing to a third person? Yes. Will it be binding? Yes, as long as it is not a violation of 1310. It must not be evidently inequitable. And number 2, it must be communicated to us. Now, this provision has been used in leasehold situations. This has been used in leasehold situations in many instances already. But do not be surprised about the holding of the Supreme Court. You know, when I was sitting in one of the classes of Dean Albano, I heard this just accidentally. And then I left. And he was talking about mutuality of contracts. You know, there was this situation. In the case of Jespaho Realty, you don't have to copy this. Realty versus CA. This Could have been in 390s, bruh. I forgot the page. I'll just remember it in around 7 minutes because of the delayed reaction. Yes. So it is in 390. The leasehold contract says this way. Let's write it so that you are going to analyze it. This lease shall be for an indefinite period as long as the lessee is up to date with his rentals. The issue is, this is a violation of the doctrine of mutuality of contracts. Because according to the lessor, this provision is so one-sided that whether or not it will be renewed is totally within the control of the lessee. In old cases in the early 1900s, this was struck down as a violation of the principle of mutuality of contracts. But in recent cases like this in 390 SPRA, the Supreme Court said, before we decide on this, let us look at the total picture. Was there a consideration for the contract, a sufficient consideration? The Supreme Court said yes. Why is this found in the contract of lease? The Supreme Court answered its own question. The Supreme Court said, because the lessor agreed. And he agreed with a consideration. Therefore, he surrendered his right to the lessee. The Supreme Court said, there is nothing wrong with that. If you surrendered a benefit to the lessee, this is a valid stipulation because this was stipulated upon with a valid consideration. That is what the Supreme Court said. You see that? But if you look at it, it's one-sided. But the fact that it is one-sided, said the Supreme Court, does not violate the principle of mutuality of contracts because you agreed. You agreed. The same case in February 26, 1998, in Allied Banking Corporation versus Court of Appeals, the same. But the provision was like this. This lease shall be renewed on like terms at the option of the lessee. If you are asked to decide on whether it is violative of mutuality of contracts, you better follow this doctrine. As long as there is a sufficient consideration for the contract, then the stipulation is a valid stipulation because the lessor agreed. And because it agreed, it is no longer one-sided. It is a product of a mutual agreement. Do you get what I mean? Yes. You read this case. This is the representative case of all this. The old cases no longer apply. And if you want to read an easier case, you read Allied Banking Corporation versus Court of Appeals on January 16, I should say. I'm sorry, January 16, 1998. That is an easier case to read. One of your reviewers even misread Allied Banking Corporation case. So you have to look at this on your own. Because if I were an examiner, I would give this example on mutuality of contracts. You know, the Supreme Court is, for me personally, correct. Because there is a similar provision in the law on sales on this. The spirit of this is also found in sales. Let's look at 1473. And you will see the spirit of the mutuality of contracts. I hope I'm right. Let's go to 1473. Look at this. You see the word never? There is the word never there. Para bang talagang absolute emphatic dito ang law. The fixing of the price can never be left to the discretion of one of the contracting parties. Never daw, never. Pero may pasabali. However, if the price fixed by one of the parties is accepted by the other, the sale is perfected. Tinanggap mo eh. Nag-agree ka eh. So, valid na. Lugi ka rito. Tinanggap mo eh. Mutuality rin ang labas. Product din of agreement. Product of agreement din na ikaw ay nagpalugi. So, it did not violate the doctrine of mutuality of contracts. You get my point? See, look at that. Now, did you see Article 1473? There you go. But there is another doctrine that you have to look into. The doctrine of relativity of contracts. 1311 of your Civil Code. This is the basis of your remedial law doctrine on real party in interests. Remember, remedial law is only based on substantive law. Contracts take effect only, emphasis on only, between the parties, the assigns, and the heirs. Relativity, related to the contract. In other words, yung mga taong related to the contract lamang ang apektado ng contract. Related. Kaya nga, relativity. Kaya ang kamag-anak natin ay relatives. Related relatives. Walang problema doon sa parties. Parties really are affected, are bound by the contract. They are really affected by the contract. They take effect between the parties. But I have one question. Why do contracts take effect also among the assigns and the heirs? They are not even parties. Why? Because of the doctrine of transmissibility of rights. Rights could be transferred. Where did you study this doctrine of transmissibility of rights? You study this in your obligations. You study this in Article 1178. What does Article 1178 say? All rights acquired in virtue of an obligation are what? Transmissible, exception, law, or stipulation. Did you see that? Look at 1178. Baka lang mali ako, hindi 1178. Is it 1178? Huh? Yes. Look at that. All rights acquired in virtue of an obligation are transmissible. That's the general rule, exception, law, and stipulations. 1311 adds one exception, the nature of the obligation. For example, look at 1408. 1408 reflects the doctrine of relativity of contracts. unenforceable contracts cannot be assailed by third persons because they have nothing to do with the contract. My daughter owns a car. She sold the car to someone else. I do not like the buyer. I hate the buyer. Can I file an action to rescind the contract because I don't like the buyer? No. Because I'm not a party. My daughter is. I am not an assignee. I am not an heir. I am not yet an heir. That's not mine. Look at 3097. We'll talk about this by way of talking about this as a general rule because we are not yet in voidable contracts. The action for annulment can be instituted only by those who are principally or subsidiarily liable. Walang pakialam ang third persons. Can we still follow? You look at 1421, for instance. That's on void contracts. You paraphrase it. You paraphrase 1421. And you will notice that the meaning is the defense of illegality of contracts is not available to third persons if you paraphrase it. Exception if their interests are directly affected. And all this actually reflect the relativity of contracts doctrine. In that Allied Banking Corporation case versus Court of Appeals on January 16, 1998, Allied Banking Corporation was a lessee of a building which housed the bank. The lease contract said 14 years. But the lease contract said it will be renewed for like term at the option of the lessee. The property was donated to someone else. That donee did not want the extension of the lease. Allied Banking attacked the donation. The Supreme Court said, you cannot attack the donation. You are not even a party to the donation. You are not an assignee. You are not an heir. So the donee took over the property. But the lease was registered. Therefore, the third persons are bound by the lease that was registered. And then there came the issue on whether or not the stipulation violated mutuality of contracts. The Supreme Court said it does not because the lessor agreed with a valuable consideration. So this case was about mutuality of contracts and about attacking a donation by a third person who has nothing to do with the contract of donation. Get my point? However, there are instances when persons who are not even parties to a contract will also be bound or will be affected or will have rights under the contract. The first exception is in the second paragraph of 1311. But because it is almost 9 o'clock, that will be the subject of another session. I'll meet you on Saturday at 8:30. Not 9, 8:30. Okay? If you are late, I will meet you at 9. Okay? Thank you very much for coming.